Good afternoon, everybody. Welcome to the Aspen Institute. My name is Meryl Chertoff. I direct the Justice and Society program here at the Institute. And sometimes when I introduce myself to people, I tell them that I'm a recovering lawyer. Here at the Justice and Society program, we run a number of workshops, roundtables, and symposia on issues relating to justice. We run a seminar out in Aspen every summer, the Justice and Society Seminar, which has been running for close to 40 years. There are a couple of graduates, including Professor Block, who are here in the room today with us. And we talk about issues of justice and fairness, equity and distribution. And for those of you who listened to the State of the Union address last night, some of the topics that the President sounded are regular fare in the summer seminar. So I invite any of you who have an interest in learning more to visit with us in Aspen this summer. We've also started an exciting new program called the Justice Circle. We are having our launch event for that in New York on Friday. We are also going to be running the Sussman conversation on the Constitution and the courts out in Aspen this summer on July 17th. And we're also doing a number of other programs relating to our topic, including a very exciting program on April 11th where we are partnering with the ABA Human Rights Section, and we will be welcoming the Madam Chief Prosecutor of the International Criminal Court, Prosecutor Bensouda. And so for any of you who are interested in any of these programs, you can see me for the Justice Circle program. My colleague Chris Robinson, I believe, is in the room. There she is, Chris. And I would welcome you to speak to Chris about that. So why is the Justice and Society program interested in this topic of the crisis in access to justice and the crisis of the legal profession? One of the sources of our interest is the World Justice Project's Rule of Law Index. The Rule of Law Index, as I think many of you know, talks about rule of law parameters around the world, and it's been very useful to us in looking at problems like the access to rule of law in the Middle East, where we have worked, and in East Asia. But one shocking fact in the World Justice Program Index on the rule of law is where the U.S. ranks in one very critical parameter, and that's access to justice. In the European and North American section of the report, the U.S. ranks 11th out of 12th in access to justice. We do well in other parameters, but there's one area where the United States is failing. What does that translate to in practical terms? Well, in Professor Krantz's new book, he reports that the Legal Services Corporation, primarily responsible for providing civil legal aid in this country, has to turn away people every year. And in New York City, it doesn't even begin to tell the story. 99% of tenants are unrepresented in eviction cases. 97% of parents are unrepresented in child support matters, and 60% of homeowners in foreclosure cases attend the state's mandated settlement conferences without the benefit of legal counsel. In a country like ours, these are shocking statistics, and I think that the statistics in D.C. are no better. The question today is both why are we doing so poorly on access to justice, and also what's going on in the profession more broadly. Why is there an access to justice crisis in a country that has too many lawyers, and what's going on in the U.S. legal profession today? So my first question to all of you, if I were a third-year student at Georgetown today. Oh, I'm sorry, I didn't even introduce my speakers here. Okay. I was about to start the question without, I was going to have the men who need no introduction get no introduction. So, okay. All right. Our first speaker, Judge David Tatel, was appointed to the United States Court of Appeals for the District of Columbia Circuit in October 1994. He graduated from the University of Chicago Law School in 1966. He had practiced law at Sidley and Austin, and he served as director of the National Lawyers Committee for Civil Rights under Law in Washington, D.C. from 1974 to 1977. He returned to private practice as an associate and partner with Hogan and Harson. And he, in 1977, became director of the Office for Civil Rights at the U.S. Department of Health, Education, and Welfare. He's been extremely active in the Legal Services Corporation and now, of course, serves on the U.S. Court of Appeals for the D.C. Circuit. Milton Regan is co-director of the Center for the Study of the Legal Profession at Georgetown University Law Center. And his work focuses on ethics, corporations, law firms, and the legal profession. He was a law clerk to Justice Ruth Bader Ginsburg when she was on the U.S. Court of Appeals for the D.C. Circuit, and for Justice William Brennan of the Supreme Court of the United States. He is a very popular professor at Georgetown Law School, and we are delighted that he's able to join us. Our third speaker is Sheldon Krantz, and actually it was the publication of Sheldon's book which was one of the motivating things that brought us all together here today. Sheldon has a new book. There are copies available for your purchase. The Legal Profession, What is Wrong and How to Fix It. So you have all the answers right here. And actually, I was saying in the back room, we have so many very distinguished people here today in the legal profession and on the question of how to reform it, that if we were doing this as a roundtable, I think in an hour we could get it all fixed up and we would no longer have an access to justice crisis. So Sheldon is a professor at the University of Maryland. He is on leave from DLA Piper, which is a law firm which is one of the legal leaders in the pro bono area. And we'll be talking a little bit about the work that Sheldon's firm is doing as well. So my first question to you gentlemen today is, if I were a third-year law student at Georgetown Law, looking out at the landscape of legal practice, and I had entered law school wanting to do good, and I was leaving with debt and concerned about doing well, would I emerge confidently forth into the world of legal practice, or would I want to run back to hide in the stacks of the Williams Library?
Well, I would hope there are some options sort of in between those. I think what you need to do really is prepare yourself even before then to, first of all, get a clear sense of exactly what the landscape looks like. And, you know, at our center at Georgetown, we try to give the students a sense of the way in which practice is evolving. There are lots of changes sort of roiling the landscape. But there's no question now that the demand for certainly law firm services has declined, which has then had a ripple effect throughout the rest of the legal market. Some of that's attributable to the recession, some of it's attributable to some structural changes in the way clients of law firms use services, which Sheldon can elaborate on. But I think someone considering a legal career needs also to focus on is the extent to which a law school really takes seriously the notion that there is a professional tradition of service, and the extent to which the law school is connected with, engages with the profession in a way that gives students some sense of exactly what practicing lawyers do once they're actually in practice. I mean, I think what law schools can do is provide, for instance, research that's not simply on doctrinal questions, but on broader empirical questions. We were talking earlier about the way in which some states have attempted to identify exactly what the needs are within those jurisdictions and how we might best serve them. I think that law schools are in a position to do that kind of research. They traditionally haven't because they haven't really focused on the profession. They haven't gone out and talked to practicing lawyers, right? I think also they need to provide a sense of where the obstacles are. You know, there was an ethics opinion last week by the New York City Bar. There was a question about whether a lawyer could enter into an employment relationship, consulting relationship with a non-legal organization simply to review forms for citizenship applications in another country. The committee, well-meaning, identified 21 different ethical rules that would have to be considered in order for the lawyer to be able to engage in that sort of a relationship. And clearly, that's a way in which the profession creates obstacles, you know, for more affordable sorts of legal resources. So I would say, you know, what students need to do as they're going forward is look to see the extent to which schools are incorporating experiential components into the curriculum on a regular basis. Not simply clinics, even though they're valuable, but others as well. And if a school isn't doing that, I think, you know, you're not necessarily going to be very well equipped to go out and do good and do well.
Judge Tatel, Legal Services Corporation was set up to provide legal services to the indigent. There are a number of cities that have legal aid societies. How is Legal Services Corporation doing, and what are the trends?
Well, what struck me when I read Sheldon's book, which by the way is excellent, on the access to justice problem, is how little things have actually changed since we set up the corporation. The statistics, Meryl, that you mentioned about the percentage of poor people in New York who don't have access to the courts in these various important areas of their lives, these are statistics that we've known about for decades. The 80% number that people often use, that is 80% of the poor who need lawyers and access to the legal system can't get it. We've known that for years, decades. My view about this is that while all of the efforts to deal with this problem, many of which Sheldon describes in his book, efforts to get increased funding for legal services, creative ways of using lawyers, dispute resolution, increased obligations of lawyers to do pro bono. All of those are very useful and should be pursued, but we've been doing it for years, and my view is that unless the legal profession as a profession takes responsibility for ensuring that everyone who needs access to the legal system can get it, we will continue to pick our way through the problem and not solve it. The legal profession's approach has always been to, and by that I mean, you know, the legal profession operating through its various organizations, the ABA, state and local bars. Legal profession's approach to this problem, ever since I've been a lawyer, has been to advocate for public money for legal services, which they do very effectively, and to focus on the individual responsibilities of lawyers to serve the poor. So that's one of the canons of professional responsibility. Is every lawyer has this responsibility, and in recent years that's been translated into actual numbers of pro bono hours that people are expected to produce. Problem with that is that it doesn't look at the overall problem. It doesn't identify what the needs are and try to find ways to solve them. It simply focuses on the needs of an individual lawyer, the responsibilities of an individual lawyer. And my view is that the legal profession actually has a responsibility to ensure that everyone who needs a lawyer can get one. After all, I mean, lawyers are not normal. It's not a normal business. We are not, lawyers aren't in the business. It's not a normal commercial business. Lawyers are officers of the court. They're critical participants in the legal system. And lawyers, the legal profession has a monopoly on the legal profession. It controls who can practice law and who can serve people. And given those two characteristics, it seems to me the legal profession can't stop simply with the provision of legal services to people who can pay. And trying through pro bono to meet some of the needs of everybody else. I think the legal profession has an actual responsibility that it should assume to, in fact, ensure that everyone who needs a lawyer can get one. And we can spend an awful lot of time about how that would be done, but my view is that unless the profession actually accepts that responsibility, we will continue as we are. And the profession has the resources to do this. The latest numbers I've seen indicate that annually the legal profession revenues are, I think, well, most recent numbers I've seen were some $280 billion a year. Partners in the 50 largest law firms average over $1.6 million in earnings. This is a profession that could fund enormous amounts of legal services for the poor. So my view has always been, let's get as much public funding as we can, set individual standards for lawyers to do pro bono, but to the extent there's a gap, which I guarantee there will be, the legal profession should step up to the plate and provide the financial resources the country needs to have lawyers make sure that every poor person, and increasingly these days, every middle-income person who needs access to the legal system can get it.
Sheldon, why don't you take up the unanswered question, or that the judge was alluding to, which is, what would it look like? Who should be responsible? The ABA, the law firms? Is this going to continue to be ad hoc, or should it be formalized in some way?
First of all, I want to say it's tough to follow Judge Tatel anytime, and certainly Milton Regan as well. Well, Meryl, I think this is a pivotal moment in the history of the legal profession, and I'm delighted that the Aspen Institute is hosting this program. Let me tell you why I think it is a pivotal moment. Last night, President Obama noted the very great disparity between the wealthiest and those left behind, and it underscored for me what special obligation the legal profession has to address this problem. As Judge Tatel mentioned, we are a helping profession, like medicine, social work, teaching, and the income levels of clients should not be relevant to the nature of the service we provide. But we have to look at the facts. Judge Tatel talked about 80%. The legal profession has largely gravitated toward representing corporate interests and the wealthiest clients. It's not surprising. Obviously, lawyers, like everybody else, want to make money. But who's left behind? It's clearly not only the poor, but if you take a look at what 80% means, or even 90%, we are talking about blue-collar workers. We're talking about small business owners. We're talking about the elderly. We're talking about retiring or returning veterans. We're talking about nonprofit corporations who cannot afford the rates that we charge. So at the same time, the question comes up, do we have too many lawyers or too few? We clearly are reaching a stage where we have too many lawyers for the limited population we're now serving. But we have far too few right now for the rest of the population. And we have every year 35,000 plus law graduates who are entering the marketplace. So what this means to me, and why I consider this such a unique opportunity, is we have to figure out a way to serve the rest of the population. It is going to mean adjustments in how much money we make, But in fact, if you take a look now at the median salaries, they're going down for graduates. So I think going back to Meryl's point, I wish we did have an hour or two together in roundtable because we would be able to address these problems. But there is no doubt as we get into the discussion, there are clear answers to these issues. But the starting point, I say, is this is a pivotal moment. Judge Pat Wald and Esther Lardent wrote a foreword to my book in which they said, change is now. Things are going to happen now. There's too much dynamic in the marketplace to mean that we can ignore the issues. And it just comes down to what change is needed, and hopefully we can start to address that during this discussion.
But isn't a lot of big law now, they're fighting over the scraps, right? I mean, there are law firms are going bankrupt, there are fewer and fewer clients, and the clients are demanding more and more. So isn't the pressure, in fact, for the law firms to do more, to try to salvage the old business model as opposed to finding a new business model?
Well, if I can start off on that, I mean, law firms, big law firms are inherently conservative institutions set up in part by demands from American lawyer to demonstrate profits per partner at the top. And that has driven the model for a number of years. And it's now a chaotic situation. And Mitt can tell you from the studies that he has done, the old notion that law firms would start young associates and build them up to partnership in 6 or 7 or 8 years, and people would stay with the firms that they start with, is broken down. And in order to pay people at the very top, partners who really don't define themselves as rainmakers are losing their way. Fewer associates are going into law firms. So law firms are turning basically on their head, and the question is how that model survives. And certainly corporate clients are unwilling to pay the old rates. So we have to start with the assumption that it's going to take time, but big law firms are going to have to change. Certainly for major sophisticated clients, there'll always be a need for a big law firm, and there'll always be a need to pay those high rates. But with respect to the rest, what happens to middle-sized law firms, solo practitioners, the world of law practice is in a dynamic place. And as I said, everybody's now worried about where the business is coming from, but there is this huge market out there that's not being met. So I have no doubt that it's a time to be more optimistic rather than discouraged if the legal profession will step up to the plate.
Mitt, this is a major area of your scholarship.
Yeah, I think what's happening is a major consolidation and segmentation, if you'll forgive the jargon for a moment, within the legal market, particularly law firms. You're getting a concentration of large firms who are fewer and fewer, who are focusing on what we think of as sort of the high-end corporate market. They're separating themselves from the rest of the firms. And I think that separation, that segmentation, provides an opportunity for many of those other firms who are not in that upper tier to rethink their business model. In essence, to opt out of the arms race, because it is something of an arms race. Profits per partner is a figure that's relevant not so much for people within the firm, it's relevant for potential laterals, because it's the currency with which a firm recruits other lawyers and indeed other law firms. Right? So I think once that trend accelerates, which I think it is, and those other firms face reality and recognize they're not all going to be doing, the very most important work for the very highest end clients, I think there's a potential there for them to be liberated, to rethink the notion that the business model has to be highly leveraged, for instance, to even rethink the notion of whether they should be a partnership. Because in a partnership, you have very much a status system of owners and everyone else, right? And if firms may well then conclude they don't need to be as large, for instance, or they may need to have closer ties to various sort of regions or cities or what have you, right? So that and as well, they begin to think about how they provide legal services, right? If you're not depending upon simply the leverage, the surplus that you get from all these associates, but you're beginning to compete based on how efficiently you can provide legal services, that can drive costs down. And those sorts of lessons then can be learned as well as you're providing not simply, say, mid-sized companies, but those who've been left out by virtue of various sorts of ways that the business model just makes it prohibitive. Along with that, ideally, I think if we can get the legal profession to begin to sort of give up its fight about trying to police what constitutes the practice of law, unauthorized practice, right? And actually try to cooperate in coming up with innovative ways of providing services, then I think we can benefit even more. So I agree with Sheldon. It's potentially a pivotal point. For those who are in firms who aspire to be in that upper tier, it seems apocalyptic, that the business model is doomed. But in fact, it provides, I think, a potential opportunity if they're willing to seize it.
If I can just add one comment, I'll give you an illustration. Number of partners in the firm I was with basically ran out of good relations with their clients because of their billable rates. So what they have done is they've gone to smaller law firms, some boutique law firms, reduced their billable rates, and have now retained that relationship with a client they could not have had in a bigger firm. There used to be concerns that middle-sized firms, smaller firms, boutique firms, let's say those that specialize on women's issues, were in trouble. I think the reverse can be true now because of the fact that smaller firms, more willing to make adjustments in rates, more willing to look for more cost-effective ways to help clients, can be a part of a wave of the future.
Judge Tatel, where does this conversation need to be going on? You talked about the obligations of the law firms, and everybody in this room has some relationship to the legal community or the legal academy. So we're talking to each other. Is this the right forum, or do we need to have a conversation about, let's say, an Affordable Care Act for legal services as a public conversation?
One with a working website? Can I just step back and talk about what's really at stake here when we're talking about access to the legal system? I mean, this is a fundamental rule of law issue. A civil society like ours depends on the rule of law. The rule of law depends on a functioning judicial system. And the rule of law depends on everybody having access to that system. I remember a couple years ago, we were hearing three. We always hear 3 cases in a day, and I was struck as I was listening to the third of the 3 cases that every one of them, in every one of the cases, we had it was either a public interest organization or an individual, either suing a major federal, 2 involved federal agencies, 1 involved a corporation. What struck me about the case is all 3 of the individuals the organizations and individuals who really had no commercial access to the legal system. They were all represented pro bono by partners in law firms. And so what you had in those 3 cases was, because the legal profession was functioning the way it should, and that is interests that had no economic access to the courts had it through pro bono assistance. And since that pro bono assistance was good, what you had there was these entities, which would otherwise not have been in the courts, basically standing on equal footing with the very powerful government and corporate interests on the other side. That's the way it should work. You know, that's the way the system's supposed to work. The problem is that isn't the way it works outside the DC circuit. You know, for our routine courts and people around the country, they don't have that kind of access. And so I mention all this because I think I mean, we can get lost in the statistics and how many hours of pro bono work and what kind of programs should function here, what kind of programs should function there. But it's important to remember. And when we talk about the obligations of the legal profession, what we're really talking about here is the rule of law. And it simply can't be that our legal profession can be satisfied with a system which basically functions with lawyers providing high quality, good legal services to organizations and interests that can pay, and everybody else is dependent either on public services or having no access to the system at all. The system just can't function that way. So there's an enormous amount at stake in these discussions.
What about the monopoly position of the profession, Sheldon? You wrote about that in your book.
Well, I'm persuaded, just picking up on Judge Tatel's point, that we're going to need to have a major overhaul in terms of making sure there's access to justice. One aspect is, you know, what lawyers need to do, whether it's mandatory pro bono or whether it's dramatically reducing rates. That's one thing. But my own view is that the access to justice crisis is so serious that the legal profession cannot address it on its own. We now have a monopoly on providing legal services, and we are far short of meeting the demand. So I very strongly support the notion of bringing non-lawyers in to work with the legal profession to address problems. Washington State recently created new regulations, in effect certifying non-lawyers to help out in certain areas after training. That program is starting in the family law area, where someone can be certified, goes through special training, is then able to work either as a part of a team with lawyers or on their own to gather basic information, to help collect documents, to do a whole variety of things. This is not a problem overall that can be solved, as has been pointed out, by just increasing pro bono, although I'm certainly, and maybe in a small population of people who feel that mandatory pro bono should be part of our obligation. But we have to do a series of things, and I think adding non-lawyers is definitely one of them. And I think we have to commit ourselves along with that to helping people represent their own interests in a whole variety of ways. So that is a sense that, that I have, that the possibilities now really exist. A number of jurisdictions are starting down the road, for example, of dealing with the non-lawyer issue, and we just have to push it along.
Judge Tatel?
Sorry, I agree with Sheldon.
Ahmed?
Yeah, I agree as well. Let me add one other dimension, which is technology. I mean, there's actually a lot that can be done. There are providers out there that are able to furnish forms, for instance, for self-help that persons can use. I have a colleague at Georgetown, Tanina Rostein, that teaches a course in which students literally develop applications that can be used for what are called expert legal systems. So someone inquiring about immigration status, for instance, or eligibility for certain benefits can go to a website and follow sort of a menu-driven template and at least get some preliminary questions, which then might enable them to approach a lawyer or another provider in a more sophisticated sort of way. But the sort of thing for which, you know, lawyers would typically charge a lot more. So technology, I think, has the potential, if used wisely, I think also to streamline a lot of the services and make them more cost effective.
And what about the role of young lawyers? Here at the Aspen Institute, my colleagues are working on something called the Franklin Project, and that's on national service. And one of the notions is that people from a variety of fields will get into national service, and of course, young lawyers are an example. But one of the problems for young lawyers is they emerge from law school, most of them, with so much debt. What are the prospects for either scaling up an LSC through something like a Franklin project or through some sort of a legal core, legal service core, and what about the impact of debt on that?
Well, I think there are surprisingly some encouraging signs there. One is, as you probably know, there are all the federally guaranteed or subsidized loans are starting to build in programs relating to the fact that if you work for public interest agencies, public defenders, it is possible over time to defer loans, to make them more income-based, to help in repayment. So that's part of it. Recently, an alum of Harvard Law School gave a substantial gift to encourage the fellowships. And I think if we can, as a profession, make a major push to find a substantial funding to increase this program, to allow students, and Met and I see these students all the time. They come into law school idealistic. They would love to work in the public interest. We have to provide them opportunities for that. 5 law schools recently paired with a project called the Gideon Project and I think the Department of Justice was involved in supporting this, to provide opportunities for people to work for public defender agencies. So this is an area that should get a lot of attention.
Judge Tatel?
Well, you know, I have a very narrow window on this through my law clerks. And I definitely have clerks who, you know, there's a little bit of self-selection here. And people, I get law clerks who are interested in public interest. And I do have clerks who I think are, because of their debt, are driven to law firms when they would prefer not to. But I also have clerks who have found some of these programs that Sheldon's talking about, where they can, even with a great deal of debt, they have managed to find programs where their law school debt is slowly paid off. So I think those are very creative, but they cost money, right? And there's no public money around for any of this right now, which brings me back to the legal profession, right? Which definitely has the money to do this. The question is, how do you get the legal profession to understand that this is their responsibility and actually to put some money behind it? Well, that's, to me, the big problem.
Judge, let me ask you your perspective on this. Are you thinking about maybe a tithing process where if you're a partner in a law firm, at the end of the year, when you get your distribution, a certain percent, 1%, 2%, 3% of that should go to support programs you're talking about?
I once figured it out. It doesn't take a very big percentage to produce a huge amount of revenue for legal services. But it would require the profession actually accepting this responsibility. What? Yeah. I was going to ask sort of an unrelated question when you were both talking about alternatives. You know, what's the situation with prepaid legal services programs? Have they made a significant dent? Is that an area that, now that's not going to help with the really poor, but for the working poor, prepaid legal services programs might work. I just have no idea how well they've done. Do you?
Well, I actually did take a look at that in doing research. And prepaid legal insurance was something that started years ago, never really took hold. But now that we have mastered the Affordable Care Act kinds of problems, it strikes me that prepaid legal insurance is potentially could be an important aspect of helping people of modest means. I would encourage law firms and others, particularly firms that are venturing out to try to deal with this 80% of the population, to work with trade unions and a whole variety of other sources to build up the value of prepaid legal services, because I think that kind of insurance could be part of the answer.
Well, many of them also have been tied to employment relationships. Right?
Unions,
and
right?
Just as we're attempting to some degree to decouple health insurance from employment, that may be something we need to do with that form of insurance as well. So if we were to move to Tatel Care and have a function,
I like the sound of that.
And have a functioning website.
The website, that website would work.
The website would work. So we have assurance of that already. But that, I think, is an important conceptual step. That sort of decoupling would be important.
Well, I want to open it up to our many experts in the audience here for questions. Yes. Can you identify yourself and ask a question?
My name is Jared Milrad, and myself and my two other young attorneys here co-founded a program that I think will deal with some of the issues that were raised called Civic Legal Corps, which is Civic Legal Corps is a new fellowship program. It's a social enterprise national program that we're building, which will help to close the justice gap in a sustainable, scalable way, meaning that we'll be providing affordable services for low and moderate income people who are caught in the justice gap. So that was mostly a comment, and also to say that our website works. And I would hope all of you who are interested in that, either if you're a young attorney or if you're interested in supporting a program like that, will check us out.
Could you
Aaron,
Would you say a little
what's your
more about what you do?
describe a little bit
Sure.
about
So our website is civiclegalcorps.org,
Yeah.
civiclegalcorps.org, and we basically, the three of us are young attorneys who have wanted to do public interest work and saw the need to do it. And the vision for our program is actually in part directly inspired by Justice O'Connor, who for a long time has talked about the need for something like this. And it'll involve having young attorneys run essentially their own legal access hub, if you will, or law firm where they'll provide affordable services to low and moderate income folks, so meaning below market rates of what most law firms and attorneys charge, but at a rate that people can afford, and that also will help sustain the program long term. At the same time, we want to provide a training facility and really some dynamic opportunities for young attorneys, because as you guys know, oftentimes we don't have the opportunity to get business skills, to really get some practical skills in law school and afterwards. So we hope to launch this fall in New York and potentially in California, and then add regions thereafter. And so hopefully we'll be an ACA version of what you guys are talking about.
Now, could you talk a little bit about the rates you might charge for the
Yes,
service?
we can. My colleagues can add to that as well, but there'll be about half of market rates in many cases. Primarily, we'll be doing civil legal cases, so everything from housing to foreclosure to bankruptcy cases. They'll be primarily on a flat fee basis, using a menu of services that we'll offer. We'll also use limited retainers and payment plans in some cases. And this has actually been done and tried and tested by several nonprofit law firms that are up and running. There's one in Minneapolis called Access Justice. There's one in Boulder, Colorado called Bridge to Justice. So this is already, it's been done in the last five or so years. And what a lot of these firms have found is they've actually had to turn people away because there's so much demand and so much need. And at the same time, they're actually able to bring in a fair amount of revenue to support the program long term.
So Mitty, Jared raises an interesting question, which is the question of legal training, and to what degree are law schools doing their job to train young lawyers who might want to go out and open solo practices, compete with the big guys and offer better rates for people who are lower income?
Well, by and large, the answer is that we're not doing a very good job, I think. I think that seems to be the consensus. But I do think that's changing as well. I mean, we've had criticisms of this for some time now, but I think they take on new urgency now. We convened a series of employer roundtables at Georgetown with our dean, Bill Traynor, in reviewing what's going on in the legal market in connection with our long-range planning process. And a consistent refrain from employers from every sector, whether it's government, nonprofit, large firm, small firm, and the like, is that students don't have a good sense of sort of the law in action, if you will. They don't have a sense of it as a tool or an instrument that can be used to accomplish, certain purposes. And certainly at Georgetown, we're fortunate to have a very strong clinical tradition, which is really excellent. But what we've done in the last few years, for instance, is expand other experiential opportunities. So we have increased our externships, placements in government agencies and nonprofits. We have developed, I think we've tripled the number of courses that are called practicum courses, where there's a classroom component, but then there's also a placement, and then sort of reflection on the two. Different schools are, I think, approaching it in different ways. One of the difficulties, as Sheldon was mentioning earlier, though, is unfortunately with some of the decline in applications, some of the budgetary constraints, some schools feel they have to make cuts in things like clinical education because of the resource constraints.
Let me just add a comment to support that. I hate to sound like a cynic about how law schools function, but there are cores of tenured faculty, senior faculty, who have had no practice experience, who love teaching doctrine. And there's nothing wrong with teaching doctrine, but they are very resistant to the notion of moving into practice-based teaching. That will not change very quickly unless alums and others who are potential sources of revenue for law schools don't start to put a demand that law schools become relevant to the profession itself. Law schools are very isolated right now. There are some movements relating to using the third year for apprenticeship, but they're starting very slowly. So I think it's another area where the profession is really going to have to pressure law schools to change in very needed ways.
Marcia Greenberger.
Marcia Greenberger. I've spent most of my career in this public interest sector with a very short initial detour at a private firm, and it was set up precisely as Judge Tatel said, to provide representation for those who didn't have the economic wherewithal or enough of an economic stake on an individual basis to be able to vindicate their rights. And in thinking about what you're discussing, and it's very much properly focused on the individual person's need to get individual legal services or a company's need, there also had been at the same time an effort to try to, through a series of mechanisms, class actions and access to the courts, to deal with individual people's needs in a large scale, more efficient, one might say, way for the legal justice system, to avoid each individual person having to vindicate his or her rights on their own. But that has been, in many important respects, eaten away at over the years. So cases that used to be able to be brought to get administrative agencies to properly handle individual complaints, for example, have no longer been able to be brought to the courts, or class action mechanisms have been substantially narrowed. And I'm wondering how you think that kind of trend affects access for individuals to the justice system.
Good question.
Judge Tatel?
Well, I mean, Marcia, you're exactly right. I mean, the limitations on class actions, on standing, tighter standing requirements, the increased limitations on the ability of courts to include institutional reform in their orders. You know, that would be a really interesting thing for someone at a law school to study, because, you know, we see these cases all the time with these additional tougher limitations on access to court opportunities, and I suspect that they must have had a significant impact, negative impact on access to court. They just have to.
I think so. I mean, talking about impact, litigation more generally, I think that is one area in which large firms might well be able to marshal the resources to bring those sorts of actions in a way that, persons who are providing services to individuals may not be. I think they have the scale, they have the resources. Sheldon can speak to that. I see Lisa Dewey's here from DLA also, who's done great work in that. But that's one of the, I think, the comparative advantages that those sorts of organizations might have, to the extent there are opportunities left available to pursue it.
Well, let me just, since you mentioned Lisa Dewey, if Lisa, if you wouldn't mind, you and Sheldon have been law partners together, and DLA really has an exemplary pro bono practice. Could you just say a few words about what DLA has done and the model that you have incorporated into the overall practice?
Sure. I'd be happy to. Well, really, our program, it is quite extensive. I mean, probably any kind of pro bono work that you can imagine, we have done. We do not have very many class action or high impact litigation cases right now. We have a couple, but not as many as we probably used to. One of the things that we have been doing is focusing on signature projects. So picking areas where we can spend significant resources over a long period of time to develop some internal expertise and then try to leverage that. So for example, we have a signature project focused on juvenile justice issues. We have one focused on domestic violence issues. We also are focusing on veterans. So certain topics or certain populations where hopefully our lawyers can learn from one another, and then also provide those training opportunities that were touched on a little bit earlier for our younger associates. So it's a pretty broad program. I don't know if there's anything more specific you'd like me to touch on,
but a serious commitment by your partners for pro bono as being part, which I think is responsive to what Judge Tatel is talking about, the profession having an obligation to do that as part of its mission, whether you define it as officers of the court or part of your ethical mission. I mean, where does it come from in the DNA of your firm?
Well, I think it does come from leadership at the top. Our lawyers average every year about 80 pro bono hours per lawyer, and that has been part of our culture for many years, even though we are in many ways a young firm that came about from several different mergers. But the firm has been very careful along the way to maintain that culture. And I think culture is something for big law that's a challenge, and pro bono can provide that kind of glue to bring people together, to integrate the firm, and to really make sure that we stand for something other than just being a business, but also being a profession. And I think one thing that I would like to comment just briefly is that in terms of pro bono at big law and the access to justice crisis, one of the things that we're starting to talk about more and more at DLA Piper, and I think other firms are as well, is this push for doing civil legal services. And I know Jim Salmon's here, and we've done some work with the Legal Services Corporation. And that is something that we need to continue to push, because there are a lot of different ways to be doing pro bono that are very sexy, whether it's global pro bono work, other kinds of pro bono work. But the access to justice crisis in this country is so important that that's something that we cannot, that what I refer to as sort of our bread and butter, we cannot let go of.
If I could just make a couple of quick observations. One is that DLA Piper also created something called New Perimeter, which is an affiliated nonprofit to work in the global pro bono area. And just picking up on, again, Judge Tatel's comment about law firms making major commitments, the idea of establishing affiliated nonprofits and investing them with the resources to tackle major pro bono should be an important development. It has not yet taken hold, but I think it should. Second observation and some concern, as the big law firm model changes and you end up with more partners and fewer associates, which is where we're going, the core of pro bono work has come from associates. And that's why there have been some declines in pro bono hours. And just in revisiting the pro bono field, if lawyers providing services at no cost or low cost is going to be a critical part of our future, we're going to have to put in pressure on, we're going to have to develop incentives, because even though Lisa talked about 80 hours per lawyer at DLA Piper, the national average of pro bono time spent by lawyers is about 3 hours a year. And that is just, not sufficient. We have a far broader obligation than that. And I also think the point is, if somebody comes in and has a legal problem and can only pay $50 or $150 or $200, how can we as a profession not link some of our services to ability to pay? Whether we're in a big firm or a medium firm or a small firm, we really have to revisit that issue.
Bert, you had your hands up before. Bert Brandenburg from Justice at Stake.
Hi, thank you. I had a kind of, might be a two-part question here. A lot of the discussion has been about the structural aspects of if you provided the insurances or changed finances or did whatever to get, is there an assumption there that you have the bodies ready, that if you simply provide better incentives, there are enough people ready to go, ready to do this, and who would do more? Or is there also a kind of hearts and minds issue, and you're talking about 3 hours a year, is a lot of the challenge to convince people who have decided to enter the profession or in the middle of going in because they're in law school to even think differently about how they'll approach this in their career in terms of their own hours, whether they'll become champions within their firms, and if so, what are the best practices for sort of either converting people or unleashing those instincts?
Well, Bert, very quickly, probably the most rewarding work I have done as a lawyer is pro bono work. You start, when people enter the profession, they often think about it in terms of idealistic terms. You then get caught up with the notion, ebb and flow of life. I think there is a massive audience out there of lawyers who are unhappy, who are struggling with what they do. It's not what they expected. And it is just a matter of our now refocusing attention on what it means to be in a helping profession. I have no doubt. There are money issues that you have to work through. That it would not take many incentives to change the culture of the profession. And about half of the lawyers in this country are now reaching, their baby boomers, who are now reaching retirement age. It's a dramatic number, 500,000 or 600,000 out of over, yeah, that's right, out of over 1 million. But if you talk to somebody at the end of their career, and they're retiring, and you ask them what their thinking is, their sense is, I really regret that I did not spend more time working on things that mattered to me. And I think that is a constant theme, and I think there is this deep reservoir to tap, and we just haven't done it yet.
I think on the other end of the demographic spectrum, I think law schools can do more to inculcate, really from the beginning, a notion that you're entering a profession which has an obligation, to provide numerous pro bono activities, to publicize those, perhaps even in some cases, maybe think about a certain, I think Maryland has a mandatory pro bono
the
graduation
card rule.
Right? But there I think it begins with that early kind of socialization about what is the nature of the profession you're going into.
Ginny Sloan and then Garrett Mitchell.
I wanted to follow up a little bit on Marcia's
Ginny,
question.
can you just identify yourself and your organization?
I'm Ginny Sloan with the Constitution Project. And I wanted to follow up a little bit on Marcia's question and take the discussion away from civil legal services to criminal legal services and the role of courts and federal and state legislators who are complicit in creating obstacles to effective criminal representation by creating all of these meritless legal obstacles to lawyers being able to make the case on the merits for their clients. And so I think we need to take it one step further beyond what the bar itself can do, and the bar needs to be working to dismantle these obstacles that the courts and the legislatures have created that prevent lawyers from doing their jobs and representing their clients adequately.
Well, I think, similar to what Marcia described with respect to the sort of the constriction of class action, we have restrictions on habeas relief, for instance, that are a real problem. And I think as well with criminal, there's also an issue just of training as well. Those who are more familiar with civil matters obviously will need some sort of instruction, and so that will inevitably have to be a component of it. But we do need to look at when we think about access to justice, it's not simply a question of sort of meeting the demand, but it's also what are the structural obstacles that are out there. I agree.
Judge Tatel?
Well, on the criminal side, I mean, Ginny's right. Is David Stern here?
Yeah.
David, you should talk about this because Equal Justice Works has spent some serious time worrying about, in the criminal area, there's even a constitutional right to counsel. But for, most people who have contact with the criminal justice system outside of the federal courts, it's pretty dreary. And David, you've run into serious obstacles in trying to provide improved counsel. Why don't you say something about that?
Sure. David Stern, and I'm with Equal Justice Works.
Right.
And we just actually had the graduation of our first class of Public Defender Corps fellows, people who spent 3 years in a program that I think maybe referred to Gideon's Promise, an organization that trains young lawyers to be public defenders. And so the first class of 18 lawyers just graduated from the program. And again, it's just what you're saying. The general process in this country is 97% of people accept plea agreements rather than getting full zealous representation for clients. How do you change that model and system? And especially given the dynamics that courts really depend on those kinds of pleas. So by creating a new generation and actually listening to the Civil Legal Corps, new entrepreneurial lawyers who have a different take and a different approach to delivering services is something I'm inspired by. I see it all the time among law students who come up with really creative and new ideas, and I think nothing like a crisis to cause people to really come up with some of those ideas. But again, I'm so inspired by the next generation of lawyers who do care passionately about these issues, both on the civil and criminal side, and who are coming up with creative solutions. But just to hit the point that I think each one of you were saying, the demand far exceeds the number of opportunities. Thousands of students go to law school wanting to do pro bono, public interest work. There are few opportunities for them while they're in law school and once they graduate. We're actually in the middle of a campaign right now called Law Students for Pro Bono, because the ABA is looking at accreditation standards. And the standard right now is law schools should have a substantial opportunity for students to do pro bono. But there's no definition, and so nobody really knows what that means. 67% of law students go to law school saying, I'm prepared to have a requirement that we do 40 or 50 hours of pro bono. So why not give a target, an aspirational goal, and that's what this campaign's about. Aspirational goal of 50 hours. It's not a requirement, it's just a target so that people, at least law schools, know what they're aiming for in terms of doing pro bono and public service work. So, again, this is all coming up in the next week or two, but it is to try to inculcate values early in a lawyer's career so that it is part of their lives throughout their careers.
David, can I just ask you a question? I wanted to ask about the parallel between what you're doing and Teach for America. Teach for America now turns away, I don't know what the numbers are, 1,000 kids for every one who gets accepted. So obviously that credential is incredibly prestigious. Are you doing anything like that, and how could you?
Similar, but on a much smaller scale. So Teach for America has the one advantage that they have over us, but we did this on the Public Defender Corps model, is that they take talent and they plug them into publicly funded positions, teacher positions, and you know when those are available. Unfortunately, there's no comparison on the on the lawyer side, except in public defender programs. But there's a timing issue, unfortunately, on the public defender side, because when they have a vacancy, they can't afford to wait until the fall to hire their new lawyer. They get clients right now who need lawyers, so what they typically do is they hire locally from somebody who is in the community, has already done appointed cases, and that just only feeds the beast. Those people are used to bad practices, and they keep on doing the same machinery that results in 97% of these plea deals, rather than bringing in some new talent. When we ran this program, just to give you a sense of the appetite, when we had the Public Defender Corps applications, we had 500 applications for 18 positions. And their qualifications, I have very tough reviewers on my staff who really just don't think anybody meets the standard. They got down to 150 and they could not cut any further. They felt like the caliber of talent, people who had done public defender work during law school, had been investigators before they went to law school, had done Teach for America or other programs where they had real world experiences. The talent was remarkable. And then when we sent them down to the public defender programs that were hiring them, they said, we've never seen talent like this before. So you have, on the one hand, extraordinary talent coming out of law schools. You have enormous needs on the other hand. Trying to make those connections happen is complicated. It's not quite as turnkey as like the Teach for America that has a nice calendar year that fits in so perfectly with, you know, fall starting and people graduating from college and being eligible for that program. But again, I think the Franklin Project is actually looking at very interesting new models of trying to take that talent that wants to do public service work and figure out avenues like residency type programs that law firms might even pay for lawyers to go and do service before they do the rest of their careers.
Now, I just want to say I'm proud to say David is a Georgetown graduate. So, so of course, I would also like to say that he learned everything he needed at Georgetown, but unfortunately that's not quite true. Sorry.
Garrett Mitchell.
I'm Garrett Mitchell. I write the Mitchell Report, and thanks very much. Two things. One slightly whimsical, the other not intended to be. It occurs to me that there would be an interesting notion for law firms or collaborations of law firms to open up emergency rooms. Though said facetiously, the point is it establishes from the outset a very different relationship between the service provider and the person who needs the service. Saying that we do pro bono is a lot different than having an emergency room. Enough of that. Second, I think it's Judge Tatel's remarks much earlier in the conversation that really got me thinking, and probably many people in this room have already done it, but I thought to myself, how did we get to a point in this country where we decided that everybody ought to have access to affordable health care, but not access to affordable law care? And I raise that really sort of as a philosophical question about us, particularly given, as Judge Tatel was talking about, that this democracy is based on the rule of law. So I think this is a fascinating thing. I just would make one final observation if I could, Meryl, and that is, if we look at law firms as professional service firms, there's a model that management consulting firms have developed. McKinsey, for example, has someone who is in charge of their non-profit practice, much in the same way they do in financial services and other arenas, so that they actually make it one of the silos in their offering. And second, Bain, some years ago, created an organization called Bridgespan, right. And which gives people an opportunity to switch back and forth, blah, blah, blah. Anyway.
Well, Garrett has captured some of the themes very well, and as the wrap-up, perhaps we'll give each of you an opportunity to respond to his observations, and of course the judge, as always, gets the last word.
Right. Well, I just want to mention that you've touched upon a lot of important concepts. The idea of an emergency room in a hospital, there is a nascent movement of some volunteer lawyers, and at University of Maryland they work with law students who are available on a somewhat emergency basis. For a half hour they will charge $10 to provide preliminary advice to address a problem. If it goes beyond that, they would try to make a referral to pro bono. So it's the model you're talking about. It makes perfectly good sense. And the idea that you mentioned, Bridgespan, which I'm very familiar with, the concept that a lot of people at Bain frankly got tired of simply representing or working on matters for high-paying clients. They wanted to do something for nonprofits, for foundations. So there was an opportunity for people at Bain to shift over to that silo that you talked about to work at half pay to deal with things that mattered. Why shouldn't law firms do the same thing, provide exactly the same opportunity? It's just these kinds of issues that we ought to be exploring. The same thing we were talking a couple of minutes ago about criminal representation and public defenders. The legal profession basically opted out of the criminal field when the public defender movement started during the 1960s. How many lawyers in the profession now devote any time at all to taking assigned cases in the criminal field after being appropriately trained? We have to gear up again to get lawyers involved in the criminal side of practice. They're just not there now. But it's another illustration for me. I think the opportunities are endless and the time is right to really start to move the profession in a different direction.
And I might, give some thought to what we as law schools may be in a particularly good position to do. One, I think, is to engage in research that does also engage with the profession. And in particular, I have in mind, the notion of doing good empirical work to document the needs that exist in various jurisdictions or even more broadly. And second as well, I think, to document the obstacles that the current set of ethical rules and other sorts of provisions create to the ability to provide services at lower cost on a more sort of streamlined basis. Second, I think that by giving our students much more experiential elements of their education, we're putting them in a mindset of being problem solvers. Right? And I think it can be enormously empowering for them to be in that sort of role. I mean, I taught a corporations course this morning where we talked about various organizational forms that you could use when you're forming a business. So there's a partnership, a limited partnership, a corporation, a limited liability company, and there are various characteristics of each of them. And it might well be that in some courses that's simply taught sort of as a matter of the law and the doctrine, and you sort of memorize those and you know them. I, in the course of the classroom, put the students in a situation where they're advising three people, each of whom has both conflicting and mutually compatible interest, to think about what sort of form they ought to choose. And each form has certain characteristics that will appeal to each of the individuals, and the lawyer's role is to try to use those legal forms as instruments to allow these people to accomplish something collectively that they couldn't on their own. Right? I think there are opportunities for us as well to begin to focus on the way that legal services are provided, not simply the content of the law. I mentioned again my colleague who's having students focus on technology and how that can be used. And finally, I think opportunities for pro bono, not only through our clinics, and through our experiential placements, but possibly through what's called sort of a low bono sort of institution. My colleague Peter Edelman has been exploring the possibility of the law school providing or sort of sponsoring something of a law firm that would be devoted to providing services to people sort of above the poverty level, but still who are constrained in terms of resources. So I think we've got to engage much more with the profession than we have if we're to play a role in this, but I think there is a role for us to play.
Judge Tatel, concluding remarks?
Well, Meryl, I actually find this whole session very reassuring. From where I sit, knowing that the Aspen Institute is concerned about this and that there are as many people in this room who would come here on this cold day to talk about this issue is, to me, very reassuring. And I've heard a whole lot of very good ideas. I do think this point you made about why is it that there seems to be such political support for affordable health care in the country and very little attention to affordable, I guess we call it legal care, when our judicial system is so critical to our democracy. And that's a really interesting question, and I'm not sure why that's the case. But I wonder whether, I doubt that anything can be done on a global scale through Congress. That's not going to happen. But I wonder if there are states or cities whose economic situation has improved dramatically in the past 2 years, where there is progressive leadership, where one might consider some model programs focusing on civil Gideon or increased, richer professional obligations of lawyers, where through the municipal or state leadership and the bar, you might be able to find a place where you could build into law some new concepts that would move at least that area towards universal access to the legal system, and you would have a useful model. I know California has enacted some legislation on civil Gideon. You know, when I listened to the new mayor of New York's inaugural speech, you know, it would be really easy to fit into his agenda some really interesting ideas about legal services. So that's a long way of saying maybe there are some local jurisdictions where some really interesting, breathtaking kind of ideas could be tested out.
Well, thank you all very much. These are provocative thoughts. Thank the audience.